The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about how to fund a buy-sell agreement. A buy-sell agreement is an agreement between owners of a business, usually a closely held corporation, LLC, or partnership, to provide a plan for one of the owners exiting the business. The triggering events that might cause the agreement to kick in might be the death or disability of an owner's desire to sell his shares or her shares of the business, the company's desire to involuntarily terminate the owner's retirement, or the owner filing for bankruptcy or divorce. A good buy-sell agreement will usually provide the following terms for each of these triggering events. So, whether the exiting owner, when one of these events occurs, has an obligation or an option to sell his or her shares to the other shareholders or to the company, whether the company or the other shareholders have an obligation or an option to buy the exiting owner's shares when one of these events occurs, how the price of the stock purchase will be determined, how the deal will be structured, and where the money for the deal will come from. And that's what we're going to talk about today, is where the money for the deal will come from. And there's a couple ways to do this. One is using life insurance. Another is creating a cash account to fund the deal. A third is a bank loan. And a fourth is using installment payments to fund the deal. So we'll talk about each of these different ways to fund the buy-sell agreement. So first, let's talk about using life insurance. This makes a ton of sense if the triggering event is the death of an owner. In this scenario, the company will purchase a life insurance policy on each of the owner's lives, and when one of the owners passes away, the company has an obligation to buy the owner's shares off of the owner's estate for a certain price, and the estate has the obligation to sell those shares for that price. And we have a different article and video about how to determine the value of the shares in the buy-sell agreement, but it's a preset price, either through a formula or the fair market value of the shares at that time, or there's other ways to do it. But the payout from the death benefit of the insurance policy on the owner's life goes to the company. The company then pays that on to the family or the estate to purchase the shares. The company wins because the company doesn't have to raise any capital in an emergency situation to buy these shares, and they don't have to be in business with the estate of the deceased owner, or with the spouse or children of the deceased owner. And the heirs win because they don't have to learn a new business, and they get a lump sum payout immediately in exchange for the shares of the deceased owner. So the problem is that only really works in a situation where an owner is dying. There's a lot of other situations that we talked about earlier where the owner can exit the business. So the other three might be better situations for those other triggering events. The second way to fund a buy-sell agreement is to have a cash account. So this is basically just the company keeps enough cash on hand to purchase the shares of an exiting owner if necessary. The downside of this strategy is that it ties up capital that could otherwise be used to grow the business. It's most effective when used in combination with a loan or installment payment. So if we want to pay an owner a lump sum as a down payment when he or she is exiting the business, and then handle the rest through installment payments to the owner over time, then the cash account might provide for the down payment. The cash account might also reduce the amount of the loan that the business would have to get in order to pay for the shares. But it's really not an ideal situation because you're tying up money that could otherwise be used to run the business at maximum efficiency. A bank loan is a third option, and this does allow the owners to run the business at maximum efficiency prior to the triggering event. They're not paying life insurance premiums before the triggering event happens. They're not stashing away cash in a cash account. They're able to use all of the business's cash to grow the business or pay distributions to the owners. However, this might be problematic because a bank may be hesitant to loan to a business in which one of the principals is leaving. The business is in a weakened state, and it might not be the most creditworthy at that time. This problem can be resolved by maintaining a line of credit prior to the triggering event occurring. So if the business just has a line of credit that's large enough to cover any potential purchase, then they don't have to worry about whether they can get a loan. It's also problematic because it requires periodic payments in a time when the business might be at its weakest. After losing one of its owners, there's going to be a strain on cash flow because the business will now have to pay off the loan that it got to buy the owner's shares. Installment payments are the fourth method to fund a buy-sell agreement. And there's kind of two flavors of installment payments. One is a situation where the owner's stock is slowly transferred over time to the company or to the other owners as payments are made slowly over time for that stock. So it might be a period of 5 years over which the stock is slowly transferred as payments are made over the course of that time. Another flavor is the stock is transferred immediately, but the owners either make a down payment or don't make a down payment and just make installments for the purchase price over time. The purchase price carries interest, and there's a promissory note that basically lays out the interest and the payments that are to be made over time. And if the owners of the business default on the promissory note, the loan is collateralized by the business itself. So the owner, if the other business owners default on the payments that they're supposed to make over time, can go after the shares of the business and basically take over the business. This is a good thing because it prevents stress on the company being required to raise capital to purchase an exiting owner's shares on short notice. But it may not be ideal for exiting owners because they're not going to receive a lump sum. They're going to be a lot of exiting owners want to be paid immediately for their shares, and in this scenario, they're basically financing the purchase of their own shares to the company, and they're going to get paid slowly over time. It also is not ideal because it places the same cash flow strain on the business at a time when it's weak that getting a loan would place. The business has to make these periodic payments at a time when it's losing an owner and probably at its weakest state. So this installment payments make a lot of sense in a couple different scenarios. One is an owner's retirement. Because the payments will gather interest, the owner will continue to receive an income from the company almost like a pension, and that's usually something that retiring owners are happy to have. Another scenario is when the owners want to disincentivize the reason for the owner leaving. So this might be the owner's desire to sell their stock to a third party, and the other owners are exercising a right of first refusal, but they don't really want to do that. They want to disincentivize it, so they make it easier on the owners that are exercising the right of first refusal that the lump sum payment's not going to be made immediately. It's going to be made over time. Or it might be the company's involuntary termination of an owner for cause. So if an owner does something to cause the company to want to disassociate from the owner, the company might not want to make the payment all at once for the stock, and you might provide for installment payments because you want to disincentivize the owner doing something bad to get disassociated. So all of these four methods may make sense depending on the triggering event and the needs and wants of the owners and the strength of the company. So, for example, the cash account might make a ton of sense for a company that just happens to have a lot of cash on hand and it's a very strong company with a big income. If it's a really strong company, you may not have to worry about funding the buy-sell agreement because the cash flow alone might cover the purchase of an owner's share. So it really depends on, again, the company's situation and the value of the owner's shares who you anticipate leaving, because that's what you have to provide for. That's the purchase price that you have to provide for. So just to recap the four methods: using life insurance, and again, this makes sense when you are dealing with an owner dying, but not usually in any other situations. Maintaining a cash account or just enough capital on hand, getting a bank loan, or using installment payments. We have lots of articles and videos at learn-about-law.com about buy-sell agreements, and really any topic we've talked about here, we probably have a more specific article and video going into more detail there. So check that out at learn-about-law.com. If you have any questions, leave them in the comment section below our post on our website or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographically spread out locations for your convenience. If you found this helpful, we'd love it if you subscribe to us on YouTube, on Apple Podcasts. I used to say iTunes, Apple Podcasts, or SoundCloud, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.